your consideration of this bill, and I look forward to your response.
Thank you, Senator. Senator Ivana Bacik to second the motion, please.
And I'd like to welcome Minister Fitzgerald back to the House again as Minister for Justice. I think I've already welcomed you here, Minister, in that capacity, but you're very welcome indeed on this important piece of legislation. I'd like to commend Senator Zappone for bringing forward this legislation, and I'm delighted and indeed honoured she asked me to second it. I'm happy to do so. I think it's a piece of legislation that recognises a lacuna and a gap and a flaw in our current legislation on sexual offences, and one which, it must be said, has been recognised and identified by many people, but Senator Zappone is the first to have actually put the work in and given the commitment to looking at how best to deal with and resolve this particular issue. And I would also like to thank Senator Zappone for the excellent briefing that she offered us in which I was delighted to attend in the Marion Hotel earlier today, chaired by Susie Byrne, the disability rights campaigner, and at which a clip from the documentary Somebody to Love by Anna Rogers was introduced by Zlatas Filipovic, and it's a really moving and powerful documentary concerning really the right to sexual autonomy of people with disabilities. So it was really important to be able to see that. And I know there was, I'm sorry I had to leave before the end, but there was also a panel of self-advocates there, and many of the people there who I know we welcome again also here today would have been very much instrumental in seeking to have legislation like this put forward. And as Senator Zappone herself has said, she created the bill in response to a call to action by the self-advocates and disabled people's organisations. It should also be acknowledged, as was acknowledged at the meeting earlier, the role of NUI Galway and the Centre for Disability Law and Policy in the formulation of this bill. In particular, Dr. Eleanor Flynn and Anna Arstein Kerslake from the Centre for Disability Law and Policy. And I should also acknowledge my own friend, of course, Professor Gerard Quinn, who's done a huge amount to put disability rights and law on disability rights to the fore in Ireland. So I think there's been a long genesis to the bill, and I do very much commend Senator Zappone for putting it together. As I say, the flaw in the legislation, the difficulty with the legislation, the fact that it's outdated has been recognised. The legislation currently is the 1993 Criminal Law Sexual Offences Act, the Section 5 of which currently creates an offence for a person who has or attempts to have sexual intercourse or commits or attempts to commit buggery with a person who is mentally impaired. And it's a very crude provision, really, which is, I think, flawed or problematic in two aspects, as Senator Zappone has outlined. First of all, because it purports to criminalise all sexual or particular forms of sexual activity with persons who are mentally impaired, irrespective of consent. The only proviso being otherwise than a person to whom they are married. So marriage provides the defence, but there's no provision of consent as a defence. But equally, it doesn't provide sufficient protection against abuse for persons who are particularly vulnerable, and that was demonstrated, as the explanatory memorandum points out, in a case in the Central Criminal Court in November 2010, where it was pointed out that particular sexual acts are not in fact covered by Section 5. So it's crude and it's inadequate in some respects, but it's also over-paternalistic in other respects, and fits in, I think, with a very outdated view of intellectual disability, which I think happily has changed. The perception and the view of disability has changed, even in the relatively short period since 1993. And, we're not talking about a very old piece of legislation. That's the irony. But I suppose, what I wanted to address really was the context for this, that if you look at our sexual offence laws generally, and I should say that I, in practice, did some work on these, and in particular acting for the state in some cases, defending aspects of sexual offences legislation. And a real problem, particularly when one is in that position of defending legislation before the courts, is that there has been so much piecemeal reform over the years, and so much of it becomes dated so quickly, or has become dated so quickly, as our understanding of, for example, offences against children has changed. So we've seen our sentencing regime for sexual offences against children change dramatically within a relatively short space of time as people become more aware. Looking even at where Section 5 is located, the section we're currently looking at amending in Senator Zappone's bill, of course, that's in the 1993 Act, which did quite a number of other things, but didn't purport to set out any sort of proper code on sex offences offences. That had been attempted in the earlier 1990 Act, which itself now is seen as somewhat problematic because it again creates a very somewhat clumsy series of sort of tiered serious offences, including this rather anomalous offence of rape under Section 4, which covers forms of rape other than that covered in the 1981 Act, common law rape. So we have all these different variants of sexual offences, and yet we have gaps where certain protections are not in fact offered, adequate protections are not in fact offered. And of course then, as a result of the CC case in 2006, which called into question a whole policy and a whole practice of charging in sexual offence cases, as a result of that we saw some hasty lawmaking to try and fill another gap concerning protection of children against sex offences, and again legislation that had to be subsequently amended. So, you know, this government has committed to an overhaul of sex offence laws. I know that last December, I think on the 17th of December, the government approved the drafting of a wide-ranging sexual offences bill, and I know it's currently being drafted and is priority legislation. But I think private members' legislation like this has an important role to play in seeking to really highlight to drafters in government what can be done to try and address problems that have been identified with existing legislation. So that now that we are looking at last, a comprehensive overhaul and codification of sexual offence laws, that we can ensure that we have up-to-date and adequate provisions in place. And I know that the government is also keen, also has to ensure indeed that there's a consistency with the assisted decision-making capacity bill, which we've been debating in the Justice Committee, and which at the hearings we've heard some similar issues around autonomy, personal autonomy and capacity to make choices. Some of the same issues that we heard about at the briefing this morning and that were evident in the documentary. So I think Senator Zappone's offered or proffered solution or resolution of the difficulties that we've identified with Section 5 is a much more elegant structure. It offers, as she said, a disability-neutral approach, which instead of providing for specific protection for persons with intellectual disability, instead creates, I suppose, breaks down what the old Section 5 sought to do into two things. First, providing for a new offence of abuse of position of dependence and trust. So a new offence which would apply to anyone who takes advantage of a position of dependence and trust in sexually exploiting or committing a sexual offence involving another person. So that is disability neutral. It doesn't offer specific protection to persons with disabilities, but rather, I think, rather elegantly shifts the focus to the perpetrator and to the issue of abuse of position of dependence and trust. Now, there are specific provisions or specific criteria for what constitutes a position of dependence and trust, including a person who provides care to another. So that would clearly cover, in many instances, carers for persons with disabilities. But it isn't limited to that. And I think, again, it covers, so it therefore seeks to resolve an issue that's not just an issue for persons with disabilities, but also for persons who are vulnerable in other ways and who may be in dependent positions. The second thing that the new legislation seeks to do is to provide for a definition of consent. And again, this goes well beyond any issues around specific offences concerning persons with disabilities. It seeks to offer a new definition of consent that again focuses on the issue of agreement and on the positive aspect of consent. This is something that feminist critics of rape laws have often called for. We don't have it yet in an Irish context. The explanatory memorandum rightly points out that, you know, the 1990 Rape Amendment Act did seek to offers to go some way towards assisting juries in defining absence of consent by providing in Section 9 that any failure or omission by a person to offer resistance does not of itself constitute consent. But again, that's a very inadequate provision, simply really stating that submission is not consent. It addressed an old myth, an old rape myth that needed to be addressed, but you know, it didn't go any further than that, and it certainly didn't provide the sort of positive affirmation of the need to ensure agreement and consent in sexual activity that I think now we recognise is imperative. I know I'm out of time. I just wanted to finish by commending Senator Zappone again by saying that I think whatever legislation the government brings forward should take account of many of the issues and principles that Senator Zappone has addressed here. Certainly the current Section 5 may not have given rise to many prosecutions, in fact almost none. It's very rarely used, but it has undoubtedly had a chilling effect on the lives of persons with disabilities, and for that reason it is a discriminatory provision that requires amending, and I do hope that we'll see the new legislation the government's bringing forward that it will incorporate respect for sexual agency of all in it. Thank you.
Thank you. Senator Power. 6 minutes, Sandra.
Thank you. I too welcome the Minister to the House and congratulate her on her recent promotion. And I would also like to commend Senator Zappone on bringing forward this bill. I also welcome the individuals and organisations that are present with us today in the public gallery. I know it's been a long fight to get this legislation, to get it on the agenda, and I think you have a powerful advocate in Senator Zappone to take this forward. I also like to acknowledge the work that's been done by individuals, by their families, by advocacy groups, personal advocates, and indeed by Anna Rogers in making the documentary. I thought it was quite powerful and quite touching documentary. I'm someone to love, and highlighting the need for change in this area. As has already been pointed out by earlier speakers, the current law is totally out of date. It's inappropriate. It stigmatises people. It's based on totally outdated and patronising attitude towards people with disabilities that takes no account of their ability to have relationships, to engage in sexual activity, to have the same aspirations that all of us have. As Senator Zappone said, simply just to have the freedom to love and to be in a relationship and to have ways of expressing that love. And I think it is beyond time that we change the law to ensure that it is disability neutral and that it's based on principle of equality, while also ensuring that there's adequate protection against exploitation and people take advantage of their position for everybody, regardless of whether they have a disability or not. People can be taken advantage of in care homes and in other environments if they're elderly or in other situations, regardless of whether they actually have a disability or not. So I very much welcome this legislation. As Senator Zappone pointed out, to address a number of different issues. So it moves towards having a definition of consent for the first time that's disability neutral, but provides a statutory definition of consent. I note that that is something that the Rape Crisis Centre and the Law Reform Commission and others have recommended. It is a complex area in some respects, and I look forward to considering that in more detail in the case law and other definitions that are used in other jurisdictions and things like that in more detail at committee stage, because it is something that would be a new departure for us. To actually put a definition in legislation. I think it would be a positive one, but it's something that we need to be very, very careful to get right. But I think it would be positive that we can have that debate at a later stage. I do agree with the principles that are being proposed, that the definition of consent would be based on considering things like understanding and communication, and that in the actual circumstances that pertain, whether the person involved is somebody with a disability or not, that those should be the key elements, and not presenting anybody with an impossible test that has been pointed out any of us could fall short of, and just to assume and categorise people with disabilities and assume that they don't have the capacity to consent, I think is wrong. I think it's important as well the bill raises the issue around educational initiatives, and that this is something that, again, advocacy groups and the Law Reform Commission have highlighted as being a gap in our current practice. I have to say we're not great on sex education in general in this country for anybody. We still have young people going to our schools that get a cursory, if any, sex education, depending on what school they're in, depending on what teacher happens to have them for that class. Some still go the whole way through school with maybe a half-hour talk on the mechanics of sex, but without any real proper education on protecting themselves, on risks, on relationships, on all of that. So I think it's an area where a lot of work needs to be done in general. But of course it is of particular importance that people with disabilities would have the same access to same sex education and to appropriate sex education as everybody else. So that people don't end up in a situation where they're vulnerable to abuse because they don't understand what's happening. And I think, again, that will be a concern of mine, that's, as things stand, is a current issue for all children, particularly when there's still schools that don't offer the Safe Schools programme. It's because it's not compulsory, there's still a small number of schools that don't offer the child protection programmes, and I think that's wrong. So I think that's a bigger issue, but I commend Senator Zappone on including that as part of this debate, because that's important, because I think everybody, all people, regardless of whether they have a disability or not. The key aspects of relationships is that people have an understanding of what's involved, an ability to spot if somebody's doing something inappropriate, to protect yourself, and to make an informed decision and an informed choice. And I think it's time that we recognise that you can't categorise people with disabilities and refuse them the option to make that choice if that's not right, and that our law needs to catch up and needs to give people, I think, as was said at the start, the freedom to love. I think this is excellent legislation. I commend Senator Conan bringing it forward. I hope, Minister, that you can support the bill. I understand that there is government legislation promised at some stage, but that deals with a much wider area than what's being proposed today, because I would like to see us get moved to committee stage where we could have a more detailed discussion on the different issues involved, and I think that would be helpful. So I commend the bill to the House. Thank you.
Thank you, Minister.
Thank you, Catherine, and for your welcome. I'd like to thank Senator Catherine Zappone for raising this very important issue, and Senator Ivana Bacik for seconding the bill here today. I was very glad to avail of the opportunity to meet with Senator Zappone and with officials from the Department of Justice and to discuss the details of the bill. I'd like to congratulate you on drafting this bill and also pay tribute to the people you've mentioned who were supportive, the advocates who've been working in this area, some of whom join us here today. Section 5 of the Criminal Law Sexual Offences Act 1993 is of its time, although as was noted earlier, it is not very old legislation effectively. We often talk here about legislation that was much, much older than this, but nevertheless, I accept that it should be repealed. It does not reflect current thinking concerning, or indeed international developments, concerning the rights of persons with disability. In particular, the 2006 UN Convention on the Rights of Persons with Disability aims to facilitate the full participation in society of disabled persons and the full realisation of their human rights. From its adoption in 2006, the UN Convention on the Rights of Persons with Disabilities set out a blueprint, really, as to what was needed to promote equality in practice for persons with disability. The impetus driving the Convention was well put in the statement of Don Mackay, Chairman of the committee that negotiated the treaty. What the Convention endeavours to do is elaborate in detail the rights of persons with disabilities and set out a code of implementation. Article 12 of the Convention views equal recognition before the law as a fundamental right of persons with disability. And the article imposes a number of obligations which senators will be very familiar with on states, and these are to reaffirm that people with disabilities have equal right to recognition before the law, to recognise that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life, to take appropriate steps to support persons with disability to exercise their legal capacity, and to provide appropriate safeguards against abuse. The Assisted Decision-Making Capacity Bill, currently before the Oireachtas, will comprehensively reform the long outdated civil law on mental capacity. It will greatly assist vulnerable persons to better manage their personal, property and financial affairs. To mirror these developments, both I and the Government are committed to amending the criminal law on sexual offences to acknowledge as far as possible the right of vulnerable persons to sexual autonomy. The challenge in mental capacity legislation is to develop legal solutions that are appropriate to diverse decision-making needs and yet are effective within the existing legal system. And the challenge in terms of criminal law is not dissimilar. The criminal law should only be used to punish the clear sexual abuse or exploitation of vulnerable persons and not to deprive them of intimate sexual relationships where that is possible. In this context, too, there are diverse decision-making needs, and the criminal law must take these into account also. Of course, as well as recognising the rights of persons with disability, the UN Convention also imposes a specific obligation to put effective legislation in place to ensure that instances of exploitation, violence and abuse can be identified, investigated and prosecuted. There is a requirement, therefore, to strike an appropriate balance between sexual autonomy for vulnerable persons who have the capacity to consent and some level of special protection so that abuse and exploitation of vulnerable persons can be effectively prosecuted. The purpose of Senator Zappone's bill, as stated in the explanatory memorandum, is to reform the sexual offences law to eliminate discrimination against people with disabilities and to ensure that people with disabilities have the same freedom to consent to sexual activity as people without disabilities. It also aims to reform the law to ensure respect for the sexual agency of people with mental impairment while also providing protection from sexual abuse. It is clear, therefore, that we share the same principal objectives. And I do want to say here today, Senator Zappone, that I have no difficulty incorporating quite a number of the concepts in your bill into the sexual offences bill currently being drafted. And I certainly would intend to do that. The bill is being drafted. It is priority legislation. Work is underway on it at present. Modern provisions to substitute Section 5 of the 1993 Act will be included in the Sexual Offences Bill, and these will be consistent with the Assisted Decision-Making Capacity Bill and will acknowledge the right of vulnerable persons to sexual autonomy. However, as I said, I also want to ensure that sexual abuse and exploitation of vulnerable persons can be effectively prosecuted. Linked to that is the clear need to avoid subjecting vulnerable persons to potentially traumatic court proceedings, including cross-examination. These are very real, as I'm sure you'd acknowledge, practical concerns that must be considered. Despite its very obvious drawbacks, given developments, as I've already said, in current thinking and discourse, the current offence in the 1993 Act facilitates prosecution of those who would exploit the vulnerable because there is no need to prove lack of consent. In other words, the Section 5 offence is an offence regardless of consent. In addition, the Director of Public Prosecutions has the discretion not to prosecute non-exploitative incidents. The Sexual Offences Bill will also create a number of new offences to enhance the protection of children from sexual exploitation and abuse, and these will be applied to vulnerable persons as well. In this way, all of these provisions combined will significantly extend the protections available to vulnerable persons in the criminal law on sexual offences. Discussions are ongoing with the Office of the Attorney-General and the Office of the Director of Public Prosecutions to complete work on the provisions to substitute Section 5 of the 1993 Act, which is the section under discussion here today. So I am a little constrained in what I can say about this particular head in the general scheme of the bill. But as soon as this work is completed and as it's ongoing, it is my intention to engage in consultations, obviously with the disability sector. Senator Zappone will be very happy to continue discussions with yourself and other interested parties. Like yourself, I am concerned to avoid labelling vulnerable persons. I want to avoid provisions which make blanket assumptions about the decision-making powers of persons with intellectual or learning disabilities, or indeed those with mental health issues or cognitive disabilities. Of course, what the law on sexual offences does is frame criminal offences. Criminal offences are committed by perpetrators, not victims, and it is the perpetrators who should be the focus of criminal law. Another requirement of the criminal law is certainty. These are the factors central to our approach, and without making, as has been said by a number of senators, without making inappropriate assumptions about the capacity of vulnerable persons. Again, I would like to thank Senator Zappone for bringing forward this private member's bill. It is complex, but it's a very important issue. The Senator's work has a fit with the work the Department of Justice is doing in this area. And quite clearly, there's no monopoly of wisdom on how to go forward in relation to this. And I genuinely want to say I look forward to contributions and work with everybody who's involved in today's debate. And I certainly will be listening to the contributions in the debate today, and will certainly consider them in the context of the development of the relevant provisions in the Sexual Offences Bill. And I won't obviously be opposing the bill today.
Thank you, Minister. Senator Barrett.
Not at the moment.
Senator Clark.
Gur mí mar de les chairlígus de chéadháilrúta aire agus stoi go bhétar agur lá má go teanna de tas láinmh agus an méid tarráte an seo go gnéintí tú leis an seanadúir a pógur gá an reachtar sin atá láthir na huaire ahrú agus ghlacha a principal leis na Maltítá sí chuirchan cín. I think it should be said after listening to your contribution that this is a good day for the Shannon. I think it's very welcome that you've said what you have, that you agree with Senator Zappone, that the law as present should be repealed, and that in principle you take the thrust of what she's putting forward, and you're accepting that, and I think we certainly support the bill as well from that perspective, and I think it's good that this is happening today in the Shannon, and I hope that the level of priority that you've indicated be given to the legislation, because we do know that you're a very busy minister with a lot on your plate, and we would hope that that this legislation that you're discussing will be moved as quickly as possible through the parliamentary process, so it could become a reality for the people who are living with the difficult situations they're in at the present. I would like to welcome all our guests to the gallery, a lot of them from my hometown of Galway, so Fáiltearmh and Cha, and it's great to see the work that's been done by Senator Zappone and the people from NUIG who are here, and also the members of the Blue Teapot Theatre Company. I might just mention a neighbour of mine called Paul Connolly, who's one of the stars of the Blue Teapot Theatre Company, and he wouldn't let me go if I didn't mention the fact that he's involved with the group. As Republicans, we in Sinn Féin believe that every person living with a disability has the right to have their whole person recognised, their capabilities valued and developed to full potential, and their dignity respected. We believe disabled people should have the right to make choices about their lives and to be consulted, heard and resourced in all matters affecting them. Disabled people should be protected against all exploitation, all regulations and all treatment of a discriminatory, abusive or degrading nature. People with disabilities have the right to a poverty-free life facilitated by direct payments to offset the cost of disability, and to equal access and equal participation in education, employment and training. People with disabilities have the right to access appropriate coordinated services. The state has the duty to provide such services, as well as proper individual needs assessments. I very much welcome Senator Zappone's bill, which aims to eliminate discrimination against those with intellectual disabilities in terms of Irish legislation concerning sexual offences. This bill will repeal the existing law, which is discriminatory in that it criminalises sexual activity of people who are mentally impaired unless they are married to one another. Here in this state, a person's mental capacity or decision-making skills are often used to restrict or deny their legal capacity. This disproportionately affects people with disabilities, whose mental capacity is more likely to be questioned than that of non-disabled people. This means that all people are not currently treated as equal in the eyes of the law. Assessing mental capacity is most commonly done via the functional test. This test requires the individual to demonstrate that for the specific decision they are able to understand the information about the decision, including the nature and consequences of the decision, use and weigh information in order to come to a decision, retain the information long enough to make a decision, and communicate that decision to third parties. However, as we've heard, there is now widespread criticism of the functional test. The UN Committee on the Rights of Persons with Disabilities stating in its general comment on Article 12 that Article 12 does not permit this discriminatory denial of legal capacity and instead requires that support be provided for the exercise of legal capacity. By using this test of mental capacity to distinguish an individual's ability to consent to sex, we are now holding people with a disability to a higher standard than the rest of the population. We do not make every citizen prove to us that they understand and appreciate the nature and consequences of their decision when they engage in sexual activity. We only demand this standard of people with a disability, and this is clearly discriminatory. Sinn Féin also welcomes the introduction of a new offence of abuse of position of dependence, or trust, which will address the law created by the abolition of the outdated Section 5. So in conclusion, I want to reiterate Sinn Féin's support for this bill, and I commend Senator Zappone for bringing it before us, and I wish her the best with it. So Fáiltearmh and Rachdiat, but with the caveat, Minister, that we do again appreciate that you're very much saying you're in favour of the thrust of this bill, and that you're bringing forward your own legislation. But I would say once more that we hope we won't be waiting for that legislation, that it's going to get caught in the quagmire of legislation that's already in the Attorney General's office, that we're often told it's on the way, but we don't see it, because the people, like the people in the gallery today, deserve their equality in this regard, and I hope that it can be brought forward as soon as possible. Good evening, Margaret.
Thank you. Senator Conway.
And I am very happy and pleased that the government are actually supporting second stage in this bill. I'd like to start off by commending Senator Sapone for putting in an enormous amount of effort to bring this legislation into the floor of the Seanad. And unfortunately, I couldn't attend your briefing in the Marion Hotel earlier on, even though my assistant Karen was there on my behalf. And I believe it was an extremely powerful and very informative session. I'd also like to welcome the people in the gallery, particularly the people who assisted you, Senator Sapone, in preparing this legislation. And indeed, the Department of Disability Law in NUIG are people whom I have had some contact with over the years and have met on numerous occasions. And, they have what I would consider a world-class research department down there, and what they're doing is certainly very well recognised internationally. So we are fortunate that we have the support of people in policy units like that to help us drive this agenda on. And indeed, as has been said by previous contributions here, this legislation, society has moved on. People with disabilities have moved on. But like so many other elements in society, this legislation is in a time warp. The 1993 legislation, although it's not that old, I would even contend that it probably wasn't appropriate even back then. So what the Minister has committed to in what's going to be a wide-ranging piece of legislation, which is being worked on at the moment, and I do agree with you, Senator O'Claherty, we would not want to see this caught in places that we have no access to, like the Attorney General's office and other places like that. I would sincerely hope that this legislation, which the Minister and her people are working on, will run in tandem, hopefully, with Senator Sapone's legislation. And indeed, when Senator Sapone's legislation does go to committee stage, it will be very interesting when that does happen to see how it progresses. But I think there is a very clear and definite commitment from the Minister to take the overall thrust and what this legislation is trying to achieve, to ensure that it does come within her own legislation when that time comes. I mean, the offence of abusive position of somebody who has responsibility is absolutely appropriate. And as the Minister has said, quite rightly, we have to strike a balance where you're protecting people and protecting our citizens, as well as ensuring that people who have the capacity to make decisions have the freedom to do that. And as Senator Sapone has quite eloquently said here today, it's about fostering love. It's about fostering companionship. It's about fostering romance. It's about fostering what we all would want and hope for and dream of and aspire to in our lives. And indeed, why should people with disabilities be treated any differently? The 1993, Section 5 of the 1993 legislation was a gross generalisation and categorised everyone in the same ambit, if you like. And I think that that's wrong, and I'm very pleased that this Seanad yet again has been the chamber to bring this and to highlight this issue and to give a voice to people who for too long have felt that there was no voice for them. I mean, the Senate, the principle of the Senate, the reason the people voted to retain the Senate is because it is supposed to, and its job is to, reflect the views of people who are perceived to be minorities. Even though I hate ever labelling minorities, majorities, any of that, we're talking really about citizens. We're talking about people who everyone deserves to be treated equal, and it's about the whole equality agenda and so on. And thankfully, we are here today, and as a result of the good work carried out by Senator Sapone, private members' time in Seanad has been dedicated to discussing this issue. And again,